Very warm good evening to one and all. So welcome back to the today's session. Today we have our guest speaker, Dr. Aditya Dilip Kumar Patil sir. We welcome you, sir. We welcome you all the participants also. So coming on to the today's topic, homeopathy patent and defining IPR is the topic for today's session. Over to you, Aditi.
Hello. Good evening. It's
Yes,
me.
Aditi.
Yeah. Am I audible?
Yes, you are audible. Yeah, please continue. Yeah.
Okay. Hello. It's me, Dr. Aditya Ghansham, BHMS PG scholar from Srimati K.B. Abad Homeopathic Medical College, Chandwad, Nasik, Maharashtra. I am addressing you all here for today's webinar. Good evening and warm welcome to all attendees and respected guest speaker of today's webinar, Dr. Aditya Dilip Kumar Patil sir. Today's webinar topic is Homeopathic patent defining IPR. Before introducing our today's speaker, initially I would like to thank Dr. Lavanya Sai, BHMS MD, PhD scholar, National General Secretary of AIHSAYA, All India Homeopathic Student and Youth Association. Also, I would like to thank Dr. Arpana Sandeep Parikh, ma'am, Professor and HOD of Department of Repertory from Srimati K.B. Abad Homeopathic Medical College, Chandwad, Nasik, Maharashtra. She is our today's webinar organizing secretary. Now, let's have brief introduction of our today's guest speaker of webinar, Dr. Aditya Dilip Kumar Patil sir. He is Associate Professor, Department of Homeopathic Pharmacy from Dr. Ulhas Patil Homeopathic Medical College and Research Institute, Jalgaon, Maharashtra. Knowing more of today's speaker, Dr. Aditya Dilip Kumar Patil sir has received his BHMS and MD in Homeopathic Pharmacy from Bharati Vidyapit University, Pune, Maharashtra, India. He has received Bamra Arogya Trust Lipi Shield Award and is also a gold medal rank holder with more than 20 research papers published and indexed in Scopus, PubMed, Web of Science, Google Scholar and UGC journals. He was working as Senior Research Fellow in Central Council for Research in Homeopathy CCRH under Ministry of Ayush, New Delhi, India. He has also worked as Ayush Medical Officer in National Rural Health Mission, NRHM, Maharashtra, Kolhapur Division in pandemic of COVID-19. He was working as research coordinator for Dr. D.Y. Patil Homeopathic College, Dr. D.Y. Patil University, Pune, Maharashtra, wherein he contributed in crucial project of stem cell research, community health research, oral cancer research, questionnaire development for remedy analysis for COVID-19, phytochemical screening, drug proving, short-term scholarship program, agro-homeopathy, cheek embryo model research, clinical trials developing memoranda for understanding MOU with Wilmar Schwab with Wilmar Schwab Pharmaceutical Private Limited Company and with Central Council for Research in Homeopathy CCRH Ministry of Ayush New Delhi India. He has also presented research paper in state, national and international conference like Liga Medicorum Homeopathica Internationalis, LMHI, UK, events Meta-Analysis Kerala, Ayush Conference Kerala, and Ayush Conference Sidco Bhavan, Navi Mumbai, India. He was assistant professor in Department of Homeopathic Pharmacy, Noble Homeopathic College and Research Institute, NHCRI, and was also conveyor officer, Ayush Educational Portal, Nodal Officer, SSIP, working as associate professor in Department of Homeopathy Pharmacy at Dr. Ulhas Patil Homeopathic Medical College and Research Institute under MUHS Jalgaon, Maharashtra. He is founder of Tech Home Research Solutions, THRS, a virtual startup for upliftment of research education for homeopathy and is currently helping the young generation budding researchers to explore the field of homeopathy. And in today's webinar too, he is going to direct the youth buddies to our attendees for gaining the knowledge on topic homeopathic patent defining IPR. So I would like to request Dr. Aditya Dilip Kumar Patil sir to carry on with the session and give insight on the interesting topic.
Okay, so okay, my voice is audible to all.
Yes, sir. It is audible, sir.
Okay, so yeah. So very good evening to all. I'm very thankful for Dr. Aditi for giving a brief intro about the what I'm currently pursuing with homeopathy and my past achievements. Before proceeding for this session, I would like to give my gestures or valuable input to Dr. Arpana Parik madam, to Dr. Lavanya Sai ma'am, because they have been very pivotal in taking up this seminar, and the activity what they are going forward is a remarkable milestone for this homeopathy. All the secretaries, national secretaries, and all the delegates who have been in association with the AIHSAYA, the whole association. I'm really thankful for them to giving me this opportunity for delivering this talk. So it is very interesting to know that is it possible that can we move our homeopathic products into a patent market, and if it is possible, then what are the consequences and what are the scope followed with the market analysis within the sphere of this globalization unit. So homeopathic patent is not at all a new topic. It has been in the discovery phases, wherein from 1796 until this century, it has been rapidly changing with their different perspectives. So, in the field of homeopathy, while taking up this particular topic, it is very important to address some essential questions. Why do we have to know this particular patent scope in homeopathy? Number one. Number two, why IPR is important for all of us. Okay. So before going forward, let us focus on some few terminologies which will help you all to understand throughout the process that how this particular field of patent act in India works with cautious precautions of all the researchers and their efforts to bring up the product into the market and to provide the complete collective data for the citizens from their different perspectives of the drug development. IPR term scope. So IPR stands for intellectual property rights. And when we try to understand in the perspectives of homeopathy, it refers to the legal protections available to innovations and creations within the field of homeopathic medicines. In India, the Patent Act of 1970 governs the patentability of inventions, including those in the pharmaceuticals and healthcare fields. So, Indian Patent Act had came into existence in the year 1970, and if you will try to understand the Homeopathic Pharmacopoeia of India, the first volume, it was published in the year 1971. Okay, so before that particular century, if you will try to understand, the agreement between various countries, as we all know, that is World Trade Organization (WTO), it came into existence for the product display of the export and imports based on cultural benefits of all the continental drafts. However, homeopathy faces specific limitations under this law, especially in terms of patent scope. So we will try to understand this with various case studies. We will try to understand this with various examples, some previous case studies, what had happened, and future roadmap to all of you all that how we can go ahead. So let us understand first the patentability criteria under the Indian Patents Act. What are the basic criteria to define the patent? To be patentable, an invention must meet the following criteria. Number one, novelty means what? not known to the public before the filing date. So whenever you're working on any new particular product or any new particular process, in such conditions, you have to be very cautious with what data you are dealing with. Okay. Inventive step must not be obvious to a person skilled in the art. Then industrial applicability must be capable of being made or used in industry. Okay, and not excluded under section 3 and section 4. Certain inventions are explicitly not patentable. So these four categories, these are mentioned in the Indian Patent Act of 1970, and wherein the emphasis is given more on the applicability of the invention. That is more important. Relevant provisions affecting homeopathy. So let us understand what can be patented in homeopathy. The question is, what all things can we patent in homeopathy? So we must first know that what all scope do we have. Number one, novel processes for preparing homeopathic medicines. So you can patent the process methods of preparation of homeopathic drugs. Okay. Innovative drug delivery systems for homeopathic drugs. So pharmaconomy or route of drug administration, you can work on that particular basis. Then third, we have new medical devices or diagnostic tools used in homeopathic practice. So this might be about selection of the remedy, or there might be possibility of analysis of the drug, their rubric analysis, or you can say for repertory analysis, the softwares and all which involved. That can be thought of in the process of this particular IPR section. What cannot be patented as per section 3 of the Patents Act? So let us understand that what all things can be patented. So we have section 3D, new forms of known medicines without enhanced efficacy. So this is the description and how it is relevant to homeopathy, that prevents patenting of trivial modifications of known homeopathic remedies. Section 3H, we have methods of treatment for humans or animals, okay, wherein homeopathic treatment methods are not patentable. Okay. Then section 3I, we have processes for medicinal, surgical, curative, prophylactic, or other treatment of humans, which covers homeopathic treatment process. Then section 3P, we have traditional knowledge. Many homeopathic remedies based on known materia medica may be excluded. So these are particular, sections which emphasize more on the particular process parts of the perspectives. However, if we try to understand with the elimination of this section 3, relevance with the homeopathy will always be depending on the particulate or the drug processing. Examples of patentable versus not patentability in homeopathy. So let us understand what can be patented in a different manner. Okay. A novel machine for potentizing homeopathic medicine. This is number one, which you can go for a patent. Number two, a new method of drug delivery. Example, it's nano encapsulation of homeopathic remedy. This particular process is already, many of them have been patented. Okay. And currently, there are various drug delivery systems which are existing in the market, but they are going for a synergistic effect, or you can say enhancing the power of the drug. Number three, we have a new non-obvious process for extraction of active principles from natural sources. This becomes a little bit of question mark, because when we are going for preparation of mother tincture, the raw material and their quality analysis parameters will always be standardized as per the HPI guidelines. However, if you are trying to work on some new particular species or different species which have not been documented in HPI, you can look forward for that particular patent process. Okay. Now, what cannot be patented means not patentability. A known homeopathic formulation, definitely, which is already existing in the market, you cannot go for the patent. Example, Arnica montana 30C. Method of treating asthma with a known homeopathic remedy, because this documentation has already been written in Materia Medica, or you can say any other protocol, so that cannot be done. And repackaging a known remedy in a different form without efficacy improvement. So this basically comes under the misbranding, or you can say about proprietary name piracy in that particular format. Now, other IPR tools for homeopathy. So, what are the other IPR tools? So, we have, while patents have limited scope, other IPR mechanisms can be used. Like we have trademarks, copyright, designs. Trademark means brand names of homeopathic products. You can go for IPR for that also. Example, we have SBL. We all know Dr. Ikwe. This can be trademarked. Okay, these are already in the market. They have already been trademarked. So I'm giving you just an example. Okay, you cannot go against their particular trademark brands. Otherwise, they might go into the court case for having a particular copyright piracy with the trademarks. Copyright, then what can be done is protection for original literature, books, or software related to homeopathy. You can go for that. And design means unique packaging or container designs can be protected. So the drum, glass files, potent as machines, files, you can go for mother teacher preservation. That can be designed and that somehow can be patented. Okay. Now let us understand Drug and Magical Remedy Act relation with Indian Patent Act in 1970. Okay, so DMR Act was brought into India in 1954. Okay, before this after independence, and in relation to the Indian Patent Act, it is very important because they have different legal purposes. Like understanding how these two laws intersect is essential for anyone trying to develop, patent, market, or advertise a homeopathic product in India. Please understand, Drug and Magical Remedy Act of 1954 has Section 3 and Section 4 mentioning that what all misbranding you can not be used for exploiting any particular drug efficacy. Okay. Number two, the termination pregnancy of the drugs, or you can say the claim of disease. There are 53 to 54 diseases wherein you cannot comment that you can treat those particular diseases. Okay. So relationship between Drug and Medical Remedies Act and Patent Acts for homeopathic products. So let us understand. Patent Act 1970 focuses more on protection of invention, novel process product services. Application in homeopathy, it's like grants patent rights for eligible homeopathic innovations. DMR Act of 1954, what it does, it prohibits misleading advertisements of drugs and magical remedies, restricted advertising of homeopathic remedies claiming to cure certain diseases. So imagine if you have prepared one product for treating cancer, okay, and you have claimed that this product, no one in this universe has been provided the claim for its efficacy, or you can say for its curative power. If this particular product is being patented in India, okay, and after which the license which you have been got is for 10 years, after which you have used for the trial, you have compiled with all the data, okay, some you can say consider about 500 to 1000 samples, and now you want to extrapolate this data with various sample size. In such conditions, if you are claiming that this particular product completely cures this particular certain cancer conditions, then definitely the product will be going to scrutiny with the DMR Act, and they will try to understand all the prophylactic profiles of the preparation of drug until the outcome from the human behavior, what they are going to get perceived. Key points of DMR Act is prohibits advertisements of drugs claiming to cure diseases listed in the schedule. Example, cancer, AIDS, sexual disorders, diabetes, etc. Applies to all systems of medicine, including homeopathy. So DMR Act is not just for homeopathy, it applies to all systems. It's a centralized act. Covers misleading claims, claims of magical properties, promotion of self-medication. So this is what the DMR Act uses. Now, what is allowed in this act is factual, non-misleading information about product composition, dosage, etc., as approved by the regulatory bodies. So, DMR Act has this particular, standardized statutory forms of the claims which you can use it. Okay, and that has to be as per the guidelines provided by the act. Prohibition, claims like guaranteed cure for cancer. You cannot directly marketize this particular concept. Okay, permanent solution for infertility, 100% remedy for diabetes, etc. So even if product is patented, so even if the product is patented, you cannot claim it 100%. If you are claiming 100%, then the question will come up with your research finding, that is how many patient or how many sample size you have seen that this particular product is showing the efficacy, and that becomes more troublemaking problem to everyone. Now, impact on homeopathic products. So let us understand what is the issue in this product. Product claims and advertising. Homeopathic products, the marketing section definitely has a lot of loopholes. Claiming cure for diseases like cancer or AIDS, traditional use or known remedies, patented but advertised misleading. Now, what is the DMR stance? Restricted, especially for scheduled diseases, prohibited in advertised section 3 and schedule of DMRA. not a valid reason to advertise magical cures, still violates DMR Act, even if the issue persistent. Okay. And what this patent act stands for? No restrictions on claims in patent specification, but advertising is still subject to DMRA. So they are bifurcated. Patent can be claimed, but its efficacy and its marketing, or you can say strategy of providing outcomes, still comes under the DMR Act. Okay. Allowed in patent application if supported by data, but not in marketing. Not patentable under Section 3P of Patent Acts. And patent protection doesn't allow misleading public claims. So this is very important of this act. Now let us understand a case study. Suppose a homeopathic company invents a novel process to prepare a remedy for diabetes. The process could be patentable under the Patent Act if novel and inventive. Okay. The company cannot advertise the product with claims like cures diabetes permanently under the DMRA. So even if it holds a patent. So you're understanding what the outcome of this particular act impact the product. Now let us understand TKDL in relation to IPA. So what is TKDL? The traditional knowledge digital library plays a crucial role in how homeopathic inventions are treated under the Indian Patent Act of 1970, especially regarding the protection of traditional knowledge and the prevention of biopiracy. So TKDL has recently been come into a picture. So before that, we were having a transitional knowledge episodes, but over the time, the government of India has realized that the ancient knowledge which has been invented in India and the that obvious the empirical sources literatures, these are one of the pioneer, or you can say the first most documented or cited references text wherein all the inventions have been a legacy, or you can say the legitimate document that needs to be put forth. TKDL and its relevance to homeopathy in the scope of the Patent Act. Traditional Knowledge Digital Library is a Government of India's initiative. What it does, let us understand its function. Documents traditional medical knowledge in a digitized, searchable, and patent examiner friendly format. Okay. Third, covers Indian systems like Ayurveda, Unani, Siddha, and Yoga, and also includes reference relevant to homeopathy when derived from traditional Indian sources. So, if you try to understand the history of homeopathy, it was in the year 1796 in Germany, wherein Dr. Samuel Hahnemann has been inventing with the process from the Synchron officinalis, the paravenin bark. Okay. However, in India, the history gets different because in India it is propagated by Honingberg and various followers with Ranjit Maharaja, and it's all particular disciples. So the information was propagated in India, but the product development process was done in Germany. Okay. But if in India, if we are inventing Indian indigenous product, in such conditions, definitely you have a scope for the patent. So you need to focus on indigenous, which you can go ahead with the outsourcing of the drugs. Makes this database accessible to patent examiners worldwide at many international patent offices to prevent the grant of patents on known knowledge. Key patent law provision, Section 3P of the Indian Patent Act 1970. So let us understand aspects. Patent applications using traditional known remedies, impact on homeopathy may be rejected if the formulation process is documented in the TKDL. So if the TKDL database has already known the formulations, then that can be rejected. But if it is not known, then definitely you have a scope. Second, homeopathic medicines based on Indian traditional remedies, example Tulsi Ashwagandha. So considered prior art under TKDL if their properties are already documented. So there also you have a scope. Okay. Drug proving of this particular drugs is not done in the other countries, but obvious, because if you will try to understand with the literature of Materia Medica Pura, the major sources of the European drugs has been documented. While in India, the drugs were invented, but the process of documentation lacked due to the drug proving protocol, which currently the government has completely come up with the homeopathic patenting trial protocol. So the government of India is working completely on this particular aspect, that is Central Council for Research in Homeopathy, for developing the protocol and preserving the indigenous proving symptoms of this homeopathic drugs. Okay. Now, innovations claiming novelty using non-Indian herbs. So, scrutinized against TKDL If found similar, the patent is likely to be rejected under Section 3P. So novelty claiming is also important. If it is found to be similar of the other drugs, or you can say similar of any of the compounds, then you cannot patent it. TKDL as it's a defensive tool. Please understand. TKDL is a defensive tool. TKDL, you can go on the Google, you can just put it on, you will get the website. Okay, you'll get all the details. And it prevents from biopiracy of Indian origin remedies being patented in the name of homeopathic abroad. So that is also important. Okay, now let us understand with a case study. So you develop a homeopathic remedy using neem for skin conditions. Okay, you took neem, you have gone with the new method of preparation, percolation, we will consider it, wherein you have extracted that drug in a percolator, okay, within the 24 hours, and after that you have quantified the mother tincture with its nanoparticles, number one, number two, quantified with the active primary metabolites, number three, you have gone for the alkaloid concentrations, they are one-to-one reactions with the protein structures, and now you have been documenting those in a pre-studies, pre-cells, in vitros, in vivos and all. Then you have gone for the drug proving protocol, wherein you are considering all the signs and symptoms within the proving aspects. You have increased the sample size, let's consider 100, and now you are documenting all the data within the time frame of, you will say, the duration of standard dosage of 30C of 4 pills TDS for 7 days, and then you are documenting all its particular human behavioral symptoms, like what we go for totality of symptoms. After that, you have understood that this particular product has sphere of action more towards skin, and now you are trying to document or patent this particular process, the symptoms, and you are trying to provide a copyright on what all you have been documented about it. If your formulation uses neem in a way already described in Ayurveda, and this is recorded in the TKDL, your patent application may be rejected under Section 3A. So you got the point. In spite of working so much hard of your efforts, but if this particular action is already been recorded in the TKDL, then definitely it is going to get rejected. So you have to be very keen about what is not patented or what is not mentioned in the TKDL search engines. However, if you create a novel delivery mechanism, extraction method, or combination with homeopathic potentization techniques that is non-obvious, it may be patentable provided it is not traditionally knowledge into it. So you have a scope of the existing indigenous drug also. International impact. So TKDL has an impact not only in India but overall over the globe. The TKDL has helped prevent over 250 patent claims internationally by submitting prior art evidence for Indian knowledge, Indian traditional knowledge, and this includes claims in the EU zone, that is Europe, US, that is American zone, UK, that comes under again in Europe only, but in the Britons and all, and Japan. Okay, so this is very important, that what can TKDL document impact in the global market. Many claims involving herbs and compounds also used in homeopathic preparation also have an impact, because we have different sources of drugs: plants, animal, minerals, sarcodes, nosodes, inchondrobelia. We have synthetic source, we have allergisol isodes. There are upcoming new sources which are getting yet not documented by the pharmacopoeia committee, but yet the patents are in the process. TKDL summarization. So let me give you a brief what we have understood about TKDL. Okay. So can I patent homeopathic drug using Indian herbs? Only if it's novel, non-obvious, and not documented in TKLD. So you got the answer. Second question: does TKDL apply to homeopathy? Yes, if the formulation or process is based on traditional Indian knowledge. Okay. Can a patent be denied based on TKDL entries? Yes, under Section 3P of the Patents Act. And fourth question: can I patent a new process using traditional ingredients? Yes, if the process is innovative and not known or documented. Yes. Now let us have some real life legal battles with PKL. What all episodes had happened in India. Three detailed case studies that illustrates how the traditional knowledge digital library has impacted patents and how these legal precedents offer strong analogies or guidance for homeopathic products derived from traditional knowledge. So case number one, it's of 2012 year. Avistajan revocation. Invention, what it was, a composition combining jamun, that is Syzygium cumin, Lavangapati, and Chidin to treat diabetes. Okay, what was the issue? The mixture was already documented in Ayurveda texts as traditional use for diabetes. What was the outcome? The Indian government revoked the patent under Section 66 of the Patents Act, labeling it mischievous and prejudicial to public interest as the claims overlapped with documented TKDL prior art. Homeopathic relevance: a homeopathic remedy formulated from these herbs risk rejections or revocation if similar uses are found in TKDL, especially without demonstrable novel potency or delivery method. So understand the mixture what this particular case had. It was already documented in the pharmacopoeia of the Ayurveda. And somehow this particular mixture were already used in homeopathic preparations also. But if you will understand, in homeopathy, we go for a single preparation method. You will not get 3 to 4 drugs mother tincture at a time. Okay, because that is not been documented or a guideline provided by the pharmacopoeia. Then next we have turmeric. You all must be knowing this case. It is in the year 1995, 1997, okay, in India. So invention was that use of turmeric for wound healing patented in the US. Can you imagine? Okay, an issue that turmeric's wound healing properties were long known and widely documented in traditional Sanskrit texts. Outcome: India's CSIR challenged the patent. USPTO revoked it due to lack of novelty and relevance in homeopathy, that a homeopathic patent claiming turmeric for healing unless it offers a truly novel process or enhances efficacy would likely be denied under Section 3 of the Patents Act. If you will understand, the origin of turmeric in Sanskrit, it was already been documented. However, the US converted those documented texts into the English content and then they completely make the mixture of the product and they patented in the year. However, later on we try to understand, because when the products from India were trying to get exported, the tariff rate got completely increased and that would make a complete chaos in the market, wherein the government of India had to get involved and the patent authority had to get involved into this case. Third, the similar case of neem, Azadaka indica. Invention: neem oil extracts for fungicidal or antiseptic application was been documented as a patent. Issue: traditional use of neem as insecticide and medicinal agent is centuries old and documented in text also. Outcome: EPO revoked the patent after evidence from TKDL. So TKDL provided the evidence that this text already has been documented in India itself and was submitted and considered. Similar successful challenges in USPTO also. These are all the officers of the patent which works on it. What is the relevance in homeopathy? Homeopathic remedies containing neem extracts are vulnerable unless the process, example, a specific potentization method, nano encapsulation, or unique combination is demonstrably novel and not in TKDL. So, if you are able to produce those products which are not mentioned in TKDL, definitely you can go ahead for the patent. Now, why this case matter for homeopathic patents? Okay, because this case they were currently been forged with the Ayurvedic contains, Sanskrit contains, and with the context of, you can say, the traditional knowledge with the herbals. Okay. However, in homeopathy, the homeopathic formulation, novel potency of delivery, international filings, and post-grant risk in India will always have these particular prospects coming over and over again. So you have to be very keen and very clear with what all idea you're sharing with whom you're sharing with, the responsibility of the parties, the third parties involvement, the risks understanding, the funding, the budgets, and the license agreements. Everything has to be pre-decided before going ahead with this process. Now, applying to homeopathic use. So pre-grant checks, TKDL database has a very impact while you are trying to search for a novel compound, and it's a homework for every invention, or you can say every inventor, that they must first know that which product they are working for or they are inventing and what they are trying to patent that particular product's dimensions. So it might be a process, it might be any compound, lead compound, it might be a particular, you can say, action or delivery of that particular drugs. Okay. In homeopathy, these are the basic which comes into the patentable. Okay. The process of mechanism, or you can say method, or you can say any inventions or process of succussion, number of times the succussion process has been done. So the numbers can be changed. So this also comes into the process. Okay, and even some of the officials have already patented it also. But the main question comes up is the outcome with the patients. Even if the product is patented, but are patients really getting treated successfully with those patent products? If it is not getting treated, the product is of no use. So that is also important. Now, let us compare the table of patent law as per the global market. So you can see India, US, Europe, EPOK, then China and Australia. So in the left column, you will see the governing law bodies, the patentable subject matter, the homeopathy products, the patentability. So you will see in India we have limited. USA, yes, we have. In Europe, we have. In China, it is considered TCM, but the criteria is very strict. Australia, yes, we have, but they require the efficacy data. I would like to give you a history that in 2015 we had the Australian government report claiming that homeopathy is a placebo by considering various clinical trials and meta-analysis data. However, the government of India and the research body CCRH they re-investigated this particular document and they claimed that these were forged and it was completely logically not fact with the data. Okay, so there were falsies which were present while this particular data which was prepared, and after the year, the government recognized and then they moved up with various screening of the trials. Similar episode had happened in 2005 with the Lancet Journal. You should know this, wherein homeopathy was claimed as a placebo by the Switzerland and various research government. Okay, so Shang et al. Was a person who was working on this particular project, and he had compiled the specific clinical trials of homeopathy, wherein the forest plot was trying to showcase that it is showing the placebo effect. So when it was re-investigated and re-clinical trial was done, the re-investigation of the meta studies was done. The claim were coming that homeopathy was ahead of the placebo. So these things will always happen in the market. This criticism will always come in the market. Every science has limitation. Every science has its own scope and limitations, its own efficacy and its products. We need to be justified about our particular domain, our limitations, before putting forward and before trying to penetrate with the others' domain and others' limitations. Okay. Then the methods which can be patented. So 3I definitely in India it's difficult. USA also it's difficult. Almost all country the methods are difficult to be patented because it has previously been documented into the literature text, and if you're trying to go for a new method, then first you need to provide that what were the deficiencies of the previous products. And there are two patents which have been documented in India based on the succussion method. The CCH has also worked on it, but the problem is that the product, again as I said in the earlier slides, you can patent it, but you cannot claim it about the efficacy. If you claim about the complete efficacy, then the DMR Act will definitely slam you and it will try to bring you down with all the effective or the comments or the outcomes of the product what you have commented into it. Then recognition with TKDL it is required but obvious because we should know that whether it is eligible or not with the available source of knowledge and with the outcome observed during the patient's trial or in the product efficacy. And last we have the delivery system. Okay, so insights and observations, let us understand what's patentable in homeopathy globally. Novel composition using rare or non-traditional ingredients, innovative delivery systems, example nanotechnology, time release global. So these are the inventions. 2010 IIT Bombay researchers have worked into it. 15 they have worked into it. The meta studies they are working to it. So these are documentations are the proof that homeopathy works. They have the science which is beyond the nanostructures and they are currently working on it. Okay. Unique potentization techniques not present in the prior art. Diagnostic tools or devices used in homeopathic practice. What's not patentable? Classical remedies from homeopathic medica that cannot be patented. Okay. Any formulation based on Ayurveda, Unani, Siddha, or ethno-medicinal knowledge that cannot be patented. Frequent protocols or therapeutic methods that also cannot be patented. And simple recombination of known components without inventive steps. Now let us understand in-pass relation with the homeopathic database. If you will go on Google and if you will go on INPASS, what does INPASS stands for? Indian Patent Advanced Search System. If you will go on this website, you will get all the data of homeopathy, homeopathy formulations, homeopathy products, the inventor's name, its complete timeline, when it was invented, what claims it was put forth. You will get a certificate, its particular SOP, how it was done, everything you will get in the impasse. Okay. Now, why impasse is very important? As I said in the earlier slide, also the formulation process, traditional knowledge, IPC, CPC classifications, everything it will be mentioned. Let us compare the impasse with the international database. Coverage of impasse will always have about the Indian origin drugs and definitely what is northern scope. Okay. While in global patents we have escape net, VIPO, that is in the international territory, and USPTO. These are the three which are internationally recognized for the patent search. Okay. So search type, you can go for the full text or the boolean, or you can go for the wildcard. Now these are the search engine methods. Okay. And similarly, but often with better chemical structures, you can definitely go ahead. Language potentiality, you have digitalized issues with the impasse. However, the higher accuracy you will see in the international databases. Classification, IPC, CPC inconsistency issues, they will be there. However, it is standardized in the IPC and the CPC applied. So the compound, the components of the, you can say the structures, the chemical, you can say dictionaries, and the impact of the molecules. Everything of that particular synthesis products, elements plus compounds, the complete mixture. You will get all the data into this particular data sets. So, amendability, visibility, that is Form 13, data not indexed, why it may be vary with the transparency with the international database. Now, Drug and Cosmetic Act of 1940 in relation to the Indian Patent Act of 1970. This is very interesting because in the Cosmetic Act, it is eligible for all the centralized processing units. Homeopathy chapter, we have say provision for homeopathic medicines, which was amended in 1969 further, specifically with the regulations. Section we have different, putting up with the definitions of legal homeopathic medicines. Okay, then manufacturing, sales, prohibitions, and laying down the license, labeling, packaging about it. If you understand, in India, the legal definition of homeopathic medicine explains that which cannot be given into parenteral routes. So the medicines which are not given through injections, those medicines are, and which are being proved with the homeopathic provings of the drug provings, okay, or with the initial, if you try to understand the recorded data, only those can be claimed as homeopathic medicines. Okay, this is the legal data. You can go and you can check it out for it. Now, license for homeopathic drugs required for manufacture, definitely it belongs with the HPI domain. Homeopathic Pharmacopoeia of India will regulate all about the monographs, its preparation and its use in the industrial purpose. Regulatory approval versus patent grant. So, concern with novelty, innovative step, industrial application. These three aspects are very important. And concern with safety, quality, and regulatory compliance. So these three are also important. And both the acts hold equal positions when we try to market any product. Please understand this. A product can be patented without being approved for sale. Okay. So Patent Act gives you this opportunity that before sale you can patent any particular product. However, a product can be approved for sale but not necessarily be patented in the Drug and Cosmetic Act. This is the major difference. Okay. And patent means marketing license, you cannot get it. Okay. For that, you have to go for intensive trials and the claims what you have got with the larger sample size. However, the DSC Act, the patent right cannot be claimed. Okay. So it's vice versa. Example. Now let us understand an example. A new homeopathic nano formulation may be granted a patent, but to sell it in India, it must get a license under Drug and Cosmetic Act via the state license authority. So you can get patent of this nano formulation by IPO, okay, and only patent can be claimed. But if you want to go for a complete business perspective of selling the product, getting the profits, and excising with the effects with various trials, or you want to import it out, for that you first require the license in the Indian state, and for international you have to enroll that particular data into their particular country's domain, and then you can get ahead. Limitations on patent claims due to standardization. So Homeopathic medicines recognized under the HPI or classical preparations. What are the limitations? Okay, then cannot be claimed as new inventions since they have considered prior art or standardized knowledge. This is reinforced by Section 3P of the Patents Act, an invention which in effect is traditionally knowledge. So I had already informed you about the TKDL process. Impact. If your formulation is already listed in the HPI or standard homeopathic text, it cannot be patented. Restrictions from DNC Act can influence patent strategy, definitely. Misbranding of the drug can happen, or unapproved claims can come under the DNC Act, and again the DMR Act also with the false misleading activities. Even if a homeopathic product has a valid patent, Section 33 can be barred if manufacturer or sale if it make false claim, uses adulterated substance, does not comply with the prescribed standards. So patented homeopathic inventions must still adhere to DNC regulations to be marketable. Please understand this. Practical scenario, novel homeopathic nasal spray delivery system. This is the scenario. Patent relevance may be patentable under process device claims. You can patent it under the process device claims. But for DNC activity, okay, requires license as per DNC Act. So even if you have made the nasal spray, but if you want to go ahead for the license of that product, the DLC will require all the proof of the documents. A known HPI remedy, that is example Nux vomica 30C, reformulated without efficacy data. A new Nux vomica has been prepared in the market. The source of the species has been changed. So there you have a scope, but you cannot patent it because why? It falls under Section 3P as per the PKDL. I have already informed you in the previous slides. Okay, and must still comply with labeling, shelf life, and dilution regulations. Dilution regulations is very important in India and everywhere. When you're coming in the industry of homeopathy, how much quantity of alcohol can be used for preparation of mother tincture, potencies, its particular byproducts? That depends on the monograph content or depends on the solvent concentration with the raw material on the initial mother tincture preparation. German homeopathic pharmacopoeia has a different alcohol the strength preparations. French has different strength preparations. American has different strength preparation. British has different strength preparation, and India, comparing with this all, because Indian pharmacopoeia was the last one to come published. It was 1971. Chronologically, 1825 German homeopathic pharmacopoeia. Then we have 1870 the British coming up. 1897 we have the French. 1898 the Americans, and 1971 the Indians. So if we try to understand the scenario, the Indian government has been based all the data with the previous pharmacopoeias. And after that, the Universal Pharmacopoeia Committee understood the issues, and then they have standardized the drug preparation process throughout the universal way by WTO agreements and all those particular perspectives. And that defines the motive of the new patent methods. A new biopotentized form of a classical ingredient with clinical data, that also need to be understood. Very patentable if efficacy is proven. Okay, it can be patented, but requires approval and batch testing as per regulation 85C. So even if you have prepared a new formulation with a clinical ingredient, for the patentable efficacy, it can be proved, but it will require the approval as per the testing protocols. And misleading therapeutic claims in marketing of a patent product. So patent may be standard, but prohibited because of under DMR Act and DAC Act. Okay. Yes. Now this for the strategy. I will go a little bit more forward. Now let us understand trademark in homeopathy. So registering and using proprietary, that is brand names in homeopathy, involves trademark protection and adherence to AYUSH and DNC regulations. Okay. What can be trademark in homeopathy? So brand name, that is example I'm giving you, SBL, Live Tea, Dr. Ikwe, R18, and these are trademarks. What cannot be trademarked? Generic name. Example, Arnica Montana Nux Vomica. This cannot be trademarked. Slogans, packaging design, this can be trademarked. Descriptive terms without distinctiveness, this cannot be trademarked. Unique coin terms, example, DGX, Homeo Plus. You know, when we try to make a product, we try to coin those terms. That can be trademarked. But deceptive names suggesting cure or unproven benefits, that cannot be trademarked. Trade dress and bottle design, if distinctive, okay, terms violating public morality or misleading claims. So this comes under this. Now let us understand legal issues and challenges. Use of generic names. Illegal to trademark homeopathic drug names for from HPI or Mitra Medica. Section 91B of Trademarks Act prohibits registration of terms that are descriptive or generic. Example, cannot register belladonna drops as a trademark because it has already been mentioned into the HPI or homeopathic Mitra Medica. Okay. Second, misleading names, unverified claims. Names suggesting cure or prevention for diseases like cancer, AIDS, diabetes may violate. In such conditions, Drug and Natural Remedy Act, objectionable advertisement that will come, and DNC Act will come. A name like Diabecure may be flagged for misleading consumers. So the impact on public might be different. So that's why the trademark can be rejected, or there can be a complete false claims, or can be the allegation put from this act. Trademark infringement between brands. Multiple homeopathic brands often fight over similar sounding names. LASA. What does LASA stands? Look alike, sound alike. Okay. So trademarks must be distinct, or else courts may grant injunctions. Example: SBA Limited versus Homeocare International. Dispute over similar brand names, confusion the public. You can search it with the Google and you will get all the data about it. Then fourth, passing off. Even unregistered trademarks are protected under common law through passing off actions. Using a name that confuses consumers into thinking it is another product can lead to litigations. Example, Baidyanath versus Dabur. Although both in Ayurvedic domain, name logos must be sufficiently distinct. Okay. Violation of Ayush guidelines. Ayush product names must not claim to be a cure unless validated. You cannot use the word or term as a cure unless it is validated. Avoid names that refer to diseases listed in DMR Act. Okay. So there are 53 to 54 diseases which are mentioned in the DMR Act. So avoid using those names in your claims. And if you are using those names for a claim, then provide the validation of it. Names like cancer heal, AIDS free, or insulin off may result in license cancellation. Okay. Best practices for a proprietary homeopathic names. Use coined fanciful names. Example, Neurotone. Why? Because more likely to be registered and protected easily. Conduct trademark search. Avoid conflicts with existing brands. Okay. Apply for class 5 pharmaceuticals. Correct category for homeopathic drugs. Avoid claims of treatment cure in name. Complies with DMR and DC regulations. Register domain name plus TM jointly. Protects online brand presence. Maintain users record. Useful in defending your trademark for cancellation due to non-use. Relevant legal provisions. So we have Act. So Trademark Act, then DSC Act, DMR Act, and IPC Act. So these all will come when your particular claims are false, or when the particular patent process has a false claims, or the outcome is not as per what which has been validated. Okay. Now, copyright in homeopathy. What is copyright? So, under the Copyright Act 1957, it protects original work of authorship, such as literature work, that is books, manuals, reports, artistic works, labels, logos, diagrams, software compilation, and data presentations. What cannot be copyrighted, or copyright does not protect? Ideas, systems, or procedures, because idea, system, or procedure is protected by Indian Patent Act. It is not protected by copyright. Formulas, clinical results patented by IPR Act, okay, and not by the copyright. Medicine, substance, or formulation, this falls under patents and not copyright. Clear? Copyright scope. Textbooks, Materia Medica, authored by an individual, these are protected. Classical Materia Medica like Hahnemann's or Organon, it is under public domain and this cannot be copyrighted. Clinical case compilation articles can be copyrighted. Raw clinical data without analysis cannot be copyrighted. Software for repertorization, example, Radha Homeopathy, these are copyrighted version, licensed version. Actual homeopathic principles, potencies cannot be copyrighted. Original product labels, packaging design can be copyrighted. Common pharmaceutical packaging design cannot be copyrighted. Marketing brochures, catalogs can be copyrighted. Standard medical claims or defense cannot be copyrighted. Now, let us understand legal issues in copyright for homeopathy. So, use of public domain content. Example, many classical texts, Hahnemann Kent, are in public domain. Anyone can reprint, translate, or adapt them without permission. Legal issues, republishing organ of medicine if no copyrighted translation used. Illegal copying of modern commentary or annotated versions without permission. Okay, so these legal battles you can hold them in the copyright. So you have to be very keen, even if you are taking any text from the previous sources, and you have to cite them. If you are trying to use a translational language, or you can say interpreting those particular sentences or phrases after your own mean, then that thing can be made with the copyright, but provided you cite it from where you have taken, or from where you have understood those material. Copying from published repertories or materia medica. Reproducing modern curated repertories, example synthesis, complete repertories, copyright infringement. Even if content is medically common, selection, structure, and arrangement are protected. Case example: unauthorized inclusion of Kane's revised repertory contained in digital software resulted in legal notice for the publisher. So, if you are taking Kane repertory, you are copying all those rubrics, and you are copying all those, you can say, the remedies and their hierarchy of intensity gradings, okay, and you are putting it without the permission of the publisher into the software, that will definitely be a copyright issue. Use of repetitive software or AI tools. Many digital homeopathy tools are protected by copyright plus license terms. Unlicensed use, distribution, or reverse engineering is illegal. Example: cracking a license of homeopathy software and using it in a clinic without permission. Example: copyright plus software piracy offense. We all know that Radar initial crack version is easily available in the market. Tomorrow, if a radar company gets to know that this particular students or this particular field of homeopaths are using the cracked version, they can file a case against you because you are using the licensed version with the cracked version, okay, which you have been using into it, and that becomes a piracy of the war. So it is not. You shouldn't be using it. You should go with the legal frames, the legal entities which are intact into it, because it's someone's IPR. It is someone's. You can say effort of preserving its particular knowledge. And if you're using it without informing him, this is not a good content of act. Okay. Then product packing and label design. Label art, font, bottle design, and color schemes can be protected under both copyright act as artistic work, trademark act as trade dress. Legal risk using similar packaging to SBL, RICO, etc. may attract both copyright and trademark infringement. So the companies also have to be different in their products. Now we will see the bottles of homeopathy, the caps are different, the labeling colors are different, the bottle size somehow the above portion are different, the bottom are different. Okay. Publishing case reports or research without consent. This also comes under the Copyright Act. Okay. Publishing identifiable patient records without consent is equal to privacy violation. Copying clinical cases from others' publication is equal to plagiarism and copyright breach. So always cite sources and obtain ethical clearance or patient permission when publishing. This is one of the important aspects we all know, and we should follow this strictly when we are documenting or publishing any case reports in homeopathy. Common legal disputes in homeopathy: book plagiarism, unauthorized translation, software piracy, branding similarity, misattributions. These are all the common legal problems. The best practices, as already said, use your own analysis, interpretation, or format. Cite all clinical source and reference. Use open access or public domain text. Use licensed software and tools. Register original content. Okay, that is optional. What you should not do. Okay, don't copy from published works without permission. No, you must never do that. Publish others' work without credit. It is not a good practice. Okay, if there are multiple authors involved, try to give credit to everyone to their efforts what they have done. Okay, then assume all classical works are copyright free. It is impossible, and you cannot keep on assuming all the things that this has came up in my mind. Literature you have read it, it has been already cited in your mind, and you should be very loyal and rational with what all documentation you're working with. Okay, if it's completely a new idea after compilation of two literatures, then you have to think about the novelty, as I have documented earlier with different strategies: INPASS service, PKDL service, and looking into the different acts and their procedures. Distribute cracked or pirated softwares. Very, this is, it's illegal in India and everywhere. So you should take a permission or you should buy a license copy of it. Ignore licensing and fair use of principles. Okay. So conclusion, copyright in homeopathy primarily protects literary, artistic and software content, not drug formulations. Okay. Legal issues mainly arise from unauthorized use of text, software or packaging. Always obtain consent, license and use original or public domain material to stay compliant. So with this, we end the session. And for detailed information on reference, SOP, forms applicable for patent, trademark, copyright publications, you can mail at thrs.patil@gmail.com, which is our Tech from Homeopathic Research, this unit, email communication channel. Or you can call at the number 8766817447. You will get all the details over it. So, if you have any questions, we can go forward.
Thank you, sir. Thank you so much for the detailed explanation regarding to the patent. Sir, if we do a thing or any idea, any uh, publication or something regarding to the patent, how many years it is valid, sir?
Yeah, so see, initially you can go for 20 years in India, okay, but that
Okay,
depends
sir.
upon the procedures about the fees what you are trying to apply, okay, and
Oh,
copyright has 60 years of it, okay, at the age of 60, the thing can be done. Again, you have to go for the renewal process, so that will define your subject of matter also.
oh, okay, okay, sir.
Yeah.
Whether it is an idea also, we can do patent, right, sir?
Yeah, but if it is not initially documented, okay,
Oh, yes, yes, sir. Then otherwise it will become.
yeah,
Uh,
it will become a case of, you can say, copyright. There's a difference.
yes, sir.
There is a difference between patent, trademark, copyright, okay, and design. So we have to be very precise in our understanding that what are we trying to go ahead with. And all of these four perspectives involves the involvement of government act, that is Drug and Cosmetic Act, Drug and Magical Remedies Act, Indian Patent Act, okay. So this will have an impact on all these perspectives.
Yes, yes, sir. Okay. Thank you, sir, for the clarification. Any other question from the participants? They are welcome. They can put the questions in the comment box so that sir will be answering. Yes.
Yeah.
There is a question from the participants, sir.
Yeah.
If if I am making a new machine for succussion process, but the mechanism already exists, but not in homeopathy, can I obtain patent for that, sir?
Your voice was little bit not audible. If, yeah, for a new drug, what you
Yes,
were
sir.
trying to say? Hello. Yeah.
Hello, sir. Am I audible, sir?
Yeah. Now you're audible completely.
Yes, sir. Yes, sir. The question is like this, sir, from the participant. If I am
Yeah.
making a new machine for succussion process, but
New
the
machine
mechanism,
discussion process.
pardon, sir,
New machine. Correct.
new machine for the succussion process, but the
Okay.
mechanism already, exists, but not in homeopathy. Can I obtain patent for that, sir?
See, for this particular concept, you must first know what are the principles of homeopathy. Okay. Now, as per pharmacopoeia, there are two processes, succussion and trituration. Okay, and the process of particular parts of those machines, those can be converted into design patents. Okay, the number of succussions, this can be patented. Okay, and if that particular formulation is not documented in the HPI, okay, then that can be further used for the as an idea perspective, provided that you need to prove that how this product is different from the previous medicines product. So two particular drugs you need to prepare, one from previous machine and one from new machine, okay, and then you have to provide the difference between those. If there is a difference in the product what your new machine is showing, then definitely you have a scope for going up for the patent.
Thank you, sir, for the clarification. And any other question from the participants, they can comment in the comment box so that sir will be answering. Yeah. I think they were clear with the topic. So I hope they are clear with the topic, sir, so that we will just wrap up the session. Aditi, am I audible to you? Okay, sir. So just we will wrap up the session. Thank you, sir. Thank you so much for in detail explanation regarding the patent and regarding the its search in TKDL website. And sir, one more question, sir. Actually, I was it got skipped actually. Uh, as
Yeah.
per, only why it is regarding there is no information regarding the homeopathy in TKDL website, sir. Is there any reason, sir, for that?
No, no. You have to use different words. Homeopathy has two different words, okay? HOMOEO, HOMEO. Then homeopathic formulation. Then you can go for a particular name of the homeopathic product. Then you will get the details into TKDL. Okay, break the
So
words into engines. Then you will get into it. It's a search strategy engine. Okay.
so ultimately, keywords play an important role. That's what
Yeah.
ultimate thing, na, sir.
Yeah. 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 Yeah.
Sure, sir. Thank you so much, sir, for the clarification. And thank you, sir. Thank you so much for the overwhelming session. It was quite knowledgeable, and we have learned so many things pertaining to IPR. And thank you all the participants for your valuable participation also. Thank you all. So we'll be right back with the one more session soon. Thank you all. Thank you so much. Yeah.
Thank you so much. Thank you so much.
Thank you, sir. Thank you so much.
And I'm thankful for all the delegates and AIHSAY, the members, King Shaw sir, Parekh madam, and Lavanya and Aditi. Okay, thank you so much for giving me this opportunity. Thank you so much. God bless
Thank
you
you,
all.
sir. Thank
Yeah,
you, sir. Thank you so much. Looking forward for many more sessions, sir. Yes, sir.
sure, 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 sure. Yeah.
Thank you, sir. Thank you so much. Yes, sir.